So, why is it important to study EU law post the referendum? The referendum on June the 23rd, whereby there was a vote to leave the EU, has prompted inquiry as to the way in which Brexit will impact on a whole range of issues, including immigration and trade. It also prompts inquiry in academic terms as to the choices that undergraduates reading law should make concerning the very study of EU law. It's not surprising in this respect that students ask why they should bother to study the subject, given that the UK looks set to exit the EU. It may therefore be helpful to set out some of the facts which will help students to make a reasoned decision on this issue. So first, the factual and legal reality is that until we leave the EU, we remain bound by EU law, including all rights and obligations under the Lisbon Treaty. Assuming that Article 50 TEU is triggered in March 2017, then the UK will exit when there's a withdrawal agreement, or if there's no agreement, then the exit occurs after 2 years. That period may indeed be extended, either because there is agreement by the member states to extend the 2-year period, or because there is some transitional deal brokered between the UK and the EU, whereby EU law, or some parts of it, continue to apply to the UK for longer. So you still got to know about EU law during that period. Second, if you are thinking of becoming a lawyer, then you will need to satisfy the training requirements laid down by the legal profession. Those requirements currently include EU law as one of the foundational qualifying subjects. So if you're reading law at university now and you wish to practice, then you must take a course in EU law. This may of course change if and when we leave the EU, but it is the present reality nonetheless. Third, students thinking about their future might, however, justifiably inquire whether it is worth taking the subject very seriously, given that Brexit will happen and that thereafter EU law will no longer be relevant to them. Matters, however, are not so simple for the following reasons. This is in part because we do not know the content of the withdrawal agreement from the EU. It might take the form of what is known in the jargon of the trade as a soft Brexit, and under a soft Brexit, the UK will gain access to the single market and be bound by the rules. Anyone studying law would therefore still have to know about this part of EU law, which is a very central and important part of EU law, but they would also have to know, in addition, the basic and central doctrinal features of EU law, such as direct effect and supremacy. But there's a less obvious reason why you will have to know about EU law, even if we leave the EU and we leave the EU without a soft Brexit. So let us imagine that we leave the EU with what is known in the jargon of the trade as a hard Brexit. We leave the EU, we are not bound by any part of EU law. Notwithstanding that, there are nonetheless very good reasons why you should, studying law at university, take and know about EU law. Why is this so? It is so for the following very simple reason, but a reason which many people fail to understand. It is this: even in a post-Brexit world, firms wishing to trade and sell goods in Europe will have to comply with EU rules. And if you are their solicitor or barrister, they will expect you to know and understand those rules so that you can advise them accordingly about what they need to do in order to comply with them. You will find it a lot easier to make those decisions and give that advice if you have studied EU law yourself. If you have not, you will not know your way around the terminology and the field as a whole. Fourthly and finally, even if EU law ceases to be a compulsory subject for the purposes of qualifying as a lawyer, it will remain on the law syllabus as an option, and students can of course then decide whether they wish to take it. There are of course many interesting subjects on the law syllabus, but EU law will remain an interesting and intellectually vibrant subject to study, notwithstanding the fact that the UK ceases to be a member of the EU. This is so for a number of reasons. EU law is characterised by a blend of law and politics. It's characterised by the creation and evolution of doctrinal concept. And it has at the heart challenges posed by the need to render substantive EU law effective across 27 different member states. Those challenges will make EU law of continuing intellectual interest for a very long time.